This is one of those cases where everything goes from routine to completely out of control. A defendant already on probation, a shocking 0.333 blood alcohol level, and a judge who is clearly not buying any excuses. What starts as confusion in the courtroom quickly turns into a serious legal reality check. The big question is, will this defendant get another chance, or is jail time inevitable?
Good morning, Robert Gill with Hicksville. Mr. Posky, this is Mr. Casino's matter.
Casino 253, Jen. All right. Your name, ma'am?
Gabrielle Pawlowski.
All right. So she has a charge here of failure to refrain from consuming alcohol, being arrested on September 4 of 25. What is she going to do?
Judge, I think the violation was picking up a new offense.
It is.
She pled guilty to 2 other counts the last time we were here. We put this one on hold. She still hasn't been charged on that case, although my understanding of Mr. Casino's the blood draw is met. So what I'm hoping to do is to adjourn this one more time.
She pled guilty to 2 other counts?
Yes. And she was sentenced to IOP. The adjustment maybe it's overdosed.
Mr. Casino, I'm lost. Your name?
Emily Casino. You
We-
sentenced her on first 2 counts, but
Wait a minute. I only have one blue bag here. And that's the failure to refrain from consuming alcohol, being arrested for OUIL on September 24, 25. That's the only one I have. I don't know why this is happening more and more lately. I just don't understand why this is happening. Can you fix this for me, please? Get the other blue back, and then I'll recall the case, if you will, please. Thanks. Which one?
that's the one. You have,
Popovsky?
yeah,
Gabrielle Christine Popovsky, 25W838818A. All right, so maybe I misunderstood Mr.
it is confusing because I included.
Your parents, Mr. Haynes.
Who would expect Mr. Posky?
Okay, your name?
Gabrielle Pawlowski.
Get that phone out of here.
Out of here?
Gotta go.
Oh,
What do I do with it?
Put it in your car.
I don't have a car.
ma'am, just stay right there. Shut the
I'll turn it off.
phone. Please. Thank you.
Emily Casino. I was just gonna say, it is confusing. We dealt with the show cause, back in October where I included that she was arrested for the offense. You had me issue it for a separate show cause for the new offense, but she has still not been charged.
What was the show cause I have of October 27th is for being arrested for OUIL.
Correct. You had me issue its own show cause, and we adjourned it to today to see the outcome. I ran her record, and she still hasn't been formally charged, but I was able to obtain the blood draw results, so I don't really know how you want to proceed.
Okay, but what I've got is she was found guilty on October 27th. Hang on. Up there to submit to chemical testing October 14th. Count 1 was dismissed on motion of the probation officer. So then I took that, it looks like, and ordered additional cost of $100, attend outpatient treatment or IOP as determined by the therapist, serve a day on the court work, and pay $35 for that. And then to remain on a sober link and test once a week. So all I've got outstanding then is this charge. But she's not been charged, right?
She is not charged, but I do have the blood draw results, so I don't know if you want.
For the results.
0.333.
Why what they're waiting for? What department is this?
It's Van Buren. I called over there today, and yeah, they were able to provide me the blood draw results. It looks like they've had them since October 15th, but I looked it up. There's no court date scheduled, and it doesn't even show up on her criminal history. It just has the permit on her driving record, no charge either.
did. Okay, so what, do you have the show cause of October 17th?
So I have a,
Let me see that. That's the problem. I didn't have that one. All right. Why did I write down not guilty plea as to count 3? I can't figure this out. There is no count 3. Or unless I assumed that, look, she should be charged with failure to refrain from consuming alcohol on the offense date.
yeah, that's what I did. No, I literally just got the withdrawal results today, so
I understand.
I-
So that's what I'm doing. She's gonna she's gonna type up a new, charge of failure to refrain from consuming alcohol. And I'm gonna have a hearing and I can rely on hearsay for her to establish that she consumed alcohol.
We haven't even had a chance to discuss how she's pleading.
No. I'm not suggesting we move right now. She's gonna do the new one. And you're going to talk to the defendant and see how you wish to proceed, okay? And I don't care how long it takes us today. I'm gonna hand you these back. I think count 3,
It's weird because I think it's technically count 1 because it's considered a technical, not a non, you know what I mean?
yeah.
So I think we might have just added.
It's a non-technical instead of a technical. I get it.
Yeah.
All right, so just bear with us and we'll be back with you, okay? Thank you. Gabriel Christine Popovsky, 25W388-188.
Early days, Nicholas Popowski.
Ma'am, your name?
Gabriel.
So the charge is she failed to refrain from consuming alcohol. And it's obviously,
Now this is where things start to tighten legally. The judge is dealing with a procedural mess, missing charges, unclear documentation, but despite all that confusion, one thing stands out: that extremely high BAC result. Even though the defendant hasn't officially been charged yet for the new offense, the court is already preparing for the consequences. Here's what's critical: when the judge mentions relying on hearsay for establishing alcohol consumption, that's actually allowed in probation violation hearings. The standard of proof is lower than in a criminal trial. So even without a formal charge, this situation is already dangerous for the defendant. And think about it, if you were in her position, would you risk pleading no contest knowing it could lead directly to jail time? Or would you fight it and take your chances in a full hearing?
commensurate with an arrest, and they think that she had a .333 on her results. How is she going to proceed here?
She hasn't been charged yet, but I'd anticipate she likely will be. I would ask the court to accept the contest plea.
That's fine. I'll be happy to do that. So is the no contest plea going to be to violation of law, or is it going to be to failure to refrain from consuming alcohol? Ma'am, if you plead no contest, it has the same effect as a guilty plea. Do you understand that?
Yes.
If you plead no contest to this charge, I could revoke your probation. That'd be a non-technical violation, and you could be incarcerated for up to 90 days. Do you understand that? And did you sign, read, and understand the advice or rights form here today? If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
And you understand all your rights, correct?
Yeah.
To the charge that you violated a law, and you understand again, I want to just cover this. I don't want you to feel uncomfortable. You understand that if you plead no contest, again, it has the same effect as a guilty plea.
Yeah.
All right, to the charge that you violated a law on September 24th, 25. How do you plead? No contest?
Yes. No.
All right, and I can refer to a report. You stipulate that there's a factual basis for this. Are you on probation or parole right now, besides to me?
No.
Anybody force you to plead no contest? All right, I'm gonna accept your plea of no contest to violating the law, being convicted of, or at least not being convicted, but committing the offense. No contest plea to OUIL. How I'm concerned about this.
If I may, because we took a plea on two other matters. I guess it's probably a couple months ago.
Right.
And in the interim, I think things have been going relatively well. So we've got this very high BLC. What's of that?
Shanna Soberling,
Yes.
you haven't violated?
Didn't you put me on it when you found out?
I know, but you haven't blown positive, you,
Been driving once a week too. And blowing.
let me do this. I need to take a recess. My staff needs to take a recess. Give me 5 minutes. I'll get Ms. Tessino out here, and I don't know what happened with the, okay, so just give me 5 minutes. Okay? John, where is Lynette Johnson's file?
I give that.
Let's do Popovsky. Well, and Emily. Gabrielle Christine Popovsky, 25W8388188. All right, counsel.
Thank you, Your Honor. Derwin has been listed possible.
Ma'am, your name?
Ski.
All right, so I told probation that I would like to see a copy of the police report. So I'm going to take a look at the police report with regard to the conviction. I'm troubled by this. I mean, I just put you on probation in July, and this is pretty outrageous. So I don't know what to tell you. What would you like to say in addition? Anything else?
Yes, Judge, because in some sort of the other violations, one of the things the court had an eye on was that Ms. Popovsky clearly needs help and needs to participate in the test of outpatient, which she's done. The testing has been, I think, close to acceptable. I think we thought that there may have been a couple of deletes, but all the other tests have been negative. That's a big step for somebody who will a 0.33 in September. So I would ask the court to stick with Ms. Popovsky for a while and see if she can continue to give.
Let me, your name?
Emily Tessino,
Let me see the screening report and the police report.
the new police report.
Yes. I don't remember what kind of record she has.
This was her first confession, the one we have around.
All right. Did you get a chance to look at this police report?
We went over it, Ms. Christina, definitely.
It was an accident too, eh? Well, you weren't talking too nice to the police. Huh?
Oh,
Here you go, Sadie. All right. What else? Anything else? Anything else?
yeah, I think all responsibility.
It's bad news when you're in here on a public in-tax and you go ahead and you get arrested for drunk driving, and I don't want you to talk about that. You got a 333. Pay additional costs of $100, serve 3 days jail right now. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. You're going to remain on the sober link. Did I give her a date on that?
No, it's just the condition of her,
Then to be on sober link device. I don't care how we do it, if she turns it in now and then comes here after.
honestly, they'll charge her an enrollment fee if she,
Okay,
so it makes sense for her just to pay, it'll be cheaper for her just to pay the 3 days.
all right, so, yeah, you'd be on a sober link device until March the 1st of 26. So can you pay the $100 down?
Yes.
Pay now, she's in custody for 3 days.
How long do you want the weekly testing to continue?
Yeah. What was she on before?
The initial,
Monthly. What was, weekly testing to continue until May 31. Then bi-weekly. Yeah, that scares me. That's what I'm gonna do. Good luck. Yeah,
if she is convicted, do you want probation to?
no. No. He essentially said this would be he was gonna treat this like a conviction. Okay?
That works.
That it wasn't for failure to consume, failure to refrain from consuming but it was for a no contest plea to the conviction. So I'm gonna give her a chance, but she's gonna have to get her act together real quick, or you're gonna end up with some dire consequences. Good luck. Have a seat over there. Thank you. Thanks, Ms. Raines.
This case ultimately comes down to one thing: accountability versus opportunity. The judge clearly recognized that the defendant had made some progress, with negative tests and partial compliance. But that 0.333 BAC? That's not a minor slip, that's a massive red flag, especially while already on probation. Legally, the court had every right to revoke probation entirely and impose a much harsher sentence. Instead, the judge chose a middle ground: 3 days in jail, continued monitoring, and strict conditions moving forward. It's a warning shot: one more mistake, and the consequences could be far worse. This is a powerful reminder of how probation isn't leniency, it's a second chance with strict boundaries. Cross that line, and the system reacts fast. Backhand index pointing right. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.